Our system doesn't require us to trust any one person. What we trust is the law. What we trust is the Constitution. What we trust is a system which, if properly followed and administered, will result in the equal application of the law to the individual. What we've seen here today from many of my colleagues is an explanation as to complaints that different people have about Judge Gorsuch. Complaints that, because they're not directed at the way he actually analyzes the law, try to blame him for something else. Try to blame him for something other than his jurisprudential approach. Try to blame him for something that has resulted either from the conduct of a third party, someone not being considered for confirmation to the United States Supreme Court, or blame him, in some cases, for the law. Laws that are actually made by Congress, or in other instances, precedent set by the 10th Circuit that he has followed faithfully in individual cases. So there's been a suggestion. Sometimes it's been implicit, other times it's been very explicit, that Judge Gorsuch is beholden somehow to individuals that have expressed support for him. This is a very, very serious claim. But there's absolutely zero evidence to back it up, not a scintilla of evidence. This is not how Judge Gorsuch decides cases, and there's nothing there to back that up. And yet my colleagues, many of them have continued rather recklessly to accuse Judge Gorsuch of being someone who is influenced on the basis of someone's identity as a party, on the basis of whether they're an individual or a corporation, a big guy or a little guy, as some of them have put it. And yet there simply is no evidence for that. And to suggest otherwise, to suggest that that has been happening, that has happened on the 10th Circuit with Judge Gorsuch's rulings, that it has happened on the Supreme Court, you might as well call a judge with whom you disagree a so-called judge. This is denigrating to our judicial system, which, while imperfect, is one that I would put on par with, and in fact above that of any in the world. Now, several members of this committee have gone so far as to sign a letter asking Judge Gorsuch to find out who funds one of these organizations in particular, called the Judicial Crisis Network, and then also to recuse himself, if he's confirmed to the Supreme Court of the United States, from any cases involving that organization or those who fund that organization. This is an odd request. In fact, it's unprecedented. And it's one that I would add is unnecessary, as Judge Gorsuch pointed out. No one else speaks for him. No one else is authorized by him or anyone else to speak for him. He speaks only for himself. And in fact, this is by design. This is why the Constitution was written the way it was. It's why we give Article III judges, including Supreme Court justices, life tenure, so that they can serve without any risk of outside influence. But the request is most definitely unprecedented when it comes to this committee. Whenever there's a Supreme Court nomination, a number of organizations will submit papers to this committee. Some will submit testimony, others will submit letters. Some of them might run advertisements. In short, people exercise their First Amendment rights to weigh in on a particular nominee. And yet, to my knowledge, based on what I've been able to discover until now, the committee has not asked a nominee to exert public pressure on any outside organization, has not asked any nominee to the Supreme Court to tell any organizations happening to speak on that nominee's behalf or purporting to advocate for the confirmation of that nominee, to out that organization's donors, to identify them. That's not the nominee's job. That's putting the nominee in a terrible position. So I'd like, Mr. Chairman, to enter for the record a list of organizations that submitted letters in connection with the nominations of Justices Kagan and Sotomayor. They're very long lists spanning several
objections
pages.
ordered.
Thank you, Mr. Chairman. In addition, I'd like to note that there were a number of other groups that have, over time, expressed their viewpoints in one way or another as to their support or opposition to various Supreme Court nominees. Many of these have been on the left. Many of these have been from organizations like, including NARAL, NOW, Move On, People for the American Way. And yet, I'd note that no member of this committee, not a single Republican, not a single Democrat, has suggested that a nominee has any obligation at that point either to identify such organizations' donors or to recuse oneself from any case involving one of those organizations or anyone contributing to those organizations. Not one. Not in the case of Justice Kagan, not in the case of Justice Sotomayor, not in the case of any other Supreme Court nominee I'm aware of. I also want to say another thing about this dark money point. Some of my colleagues have characterized this as the natural outgrowth of Citizens United. And this is not the outgrowth of Citizens United. In fact, this line of reasoning ignores the fact that the Supreme Court upheld the FEC's disclosure rules in Citizens United by a vote of 8-1. It ignores that lower courts have used that part of the decision to uphold other disclosure requirements. It ignores the fact that in 2010, in a different case called Doe versus Reed, the Supreme Court upheld other disclosure requirements. So if you have issues with lack of disclosure as mandated by federal law, perhaps we should talk about that in connection with the legislative discussion.
Yes, he's right.
If you want to change the law, let's talk about changing the law, but make sure that you're not blaming something on the Supreme Court that the Supreme Court didn't do. And you certainly shouldn't blame something on Judge Gorsuch that Judge Gorsuch didn't do, especially to the extent you're talking about setting federal policy, about making federal law. That, after all, is Congress's job. And the inadequacy of the law there has to be pinned back on us, not someone else. I also want to address this notion that somehow there is a big guy, little guy dichotomy that we need to be worried about, that Judge Gorsuch is opposed to the little guy and always favors the big guy. Well, it's worth noting something that Chairman Grassley alluded to earlier. There was a statement made by Professor Noah Feldman, a professor of law at Harvard, himself a self-described liberal law professor at Harvard, who referred to this attempt to smear Judge Gorsuch as, quote unquote, a terrible idea. That was the portion of the statement that Chairman Grassley quoted earlier. I'd like to share a little bit more of that statement, where after explaining that it's a terrible idea, he goes on to explain some of the reasons why, including the fact that siding with workers against employers isn't a jurisprudential position. It's a political stance. And justices, including progressive justices, shouldn't decide cases based on who the parties are. They should decide cases based on their beliefs about how the law should be interpreted, close quote. So Professor Feldman, again, himself a self-described liberal, is right. This is a bedrock principle in the rule of law and in the American legal system under our Constitution, that judges don't. In fact, they should never decide cases based on the identity of the individual parties. That's not how it works. It's not ever how it should work. It's one of the reasons why, as Judge Gorsuch has so carefully explained, that you show me the rulings of a judge who always agrees with his or her own decisions, always feels comfortable with them as a matter of policy outcomes. And I'll show you someone who's not a very good judge. His judges aren't there to decide cases on the basis of the identity of the parties. Now, if you think Wong or Luke P. was wrongly decided, or if you think Judge Gorsuch's separate opinion in Trans Am trucking was wrong, then make a legal argument. Make a legal argument. Let's talk about the text, about how the statutory text in that case was interpreted. That's the appropriate discussion to have here. If you're worried about the driver in the Trans Am trucking case, let's talk about statutory construction rather than talking about the outcome. if you want me or if you want Judge Gorsuch, if you want anyone to defend whether or not the law was written in that case, well, that's a different equation altogether. That deals with Congress. That's our fault. If what you want to do is talk about whether or not the employer made the right decision to terminate the driver in Trans Am trucking, I don't think anyone in this room is going to do that. As far as I can tell, it was a foolish decision to fire that trucker. I don't think Judge Gorsuch, were he to opine on that, would disagree. But that wasn't the question before him. The question before him was whether federal law had something to say about whether or not that decision could be legally upheld. The law, as he very carefully analyzed it, would not allow judicial intervention in that circumstance, and that is exactly the kind of jurist we need. Now, again, if you disagree with his legal analysis in that case, let's talk about it in terms of his legal analysis, rather than on the basis of the identity of those parties. Everyone on this committee is familiar enough with the law and the cases to do that. I can only assume that in instances where people can't identify enough of a statutory textual reason to disagree with them, perhaps they want to change the subject to something else, and so they turn to the identity of the parties. In any event, these are a few cherry-picked cases out of 2,700 cases that Judge Gorsuch has decided in his 10 years on the bench. They ignore cases where Judge Gorsuch has sided with the little guy, cases like Gutierrez-Brizuela versus Lynch, cases like AM v. Holmes, Fisher versus City of Las Cruces, Orr versus City of Albuquerque, Williams v. WD Sports, and Walton v. Powell. I'm wondering why these cases don't count, why these don't somehow tally up. I wonder why, in arguing that Judge Gorsuch is somehow out of the mainstream, how a judge that is so wildly out of the mainstream that he can't be confirmed to the Supreme Court of the United States could have, in 2,700 cases, spanning an entire decade of judicial service on the U.S. Court of Appeals for the 10th Circuit, have been, how that same person who was so out of the mainstream could have been 97% of the time in a unanimous posture with the colleagues on his court, remembering, of course, that as an appellate judge on the 10th Circuit, he never sits alone. He's sitting always in a panel, usually a panel of 3 judges, sometimes in an en banc posture where he sits with a dozen or so of his colleagues. So in 97% of the cases, he reached a ruling that was unanimous with his colleagues with whom he was sitting. In 99% of the cases, he was in the majority. That is not the background of a judge who's out of the mainstream. If you don't think Judge Gorsuch should be confirmed, focus on his jurisprudential approach. If you disagree with some of his rulings, focus on his legal analysis.
That's going to be a problem for us.
At the end of the day, it's difficult to imagine a judge who is more well-prepared, more well-credentialed, or more well-suited as a matter of judicial interpretation, of statutory construction, a matter of judicial temperament.
What he's saying is
I'm honored to support the confirmation of Judge Gorsuch and encourage my colleagues to do the same. Thank you, Mr. Chairman.
Senator Klobuchar.